In this module, we're going to be talking about the legal issues around franchising. So I can promise you two things. First of all, it's going to be boring, but secondly, it's really, really important. Why is it important? Because franchising can be heavy in disputes and therefore litigation. If you think about it, franchise agreements are long, complex agreements that last a long time, that are issued to a large number, you hope, of franchisees. And so that's a recipe for problems down the line. And you want to avoid disputes, you want to avoid litigation. However much you love your lawyer, you really don't want to make him rich. And the purpose of this session is to give you a heads up on a number of the issues that you should be aware of, and hopefully you won't be spending money or large sums of money with your lawyer. Right, we're going to be focusing on 5 issues. First of all, misrepresentation and disclosure. Secondly, we'll be looking at the operations manual and its role and what does it do, because it's a slightly odd document. Then we'll be talking about dealing with non-performance. Inevitably, however clever you are at recruiting your franchisees, there will be some franchisees who simply don't comply with the system or don't do very well. Then we'll look at how to deal with disputes, and then finally we'll look at terminating a franchise agreement. So let's go straight away and look at this really important issue of misrepresentation and disclosure. What is misrepresentation? It's a technical legal word for not telling the truth. It really is as simple as that. So if you as a franchisor tell a prospective franchisee something that is not true, that is potentially a misrepresentation. And particularly if the purpose of your untruthful statement is to encourage that franchisee to enter into your franchise agreement. Now, it's really difficult because you've set up your franchise, you're really, really keen to expand, you're really keen to recruit franchisees. And so inevitably you want to say positive things about your franchise, and that's good, but you have to make sure that you can defend every statement you make. Now, of course, your franchise agreement will contain a clause that tries to protect you from misrepresentation claims. But there is nothing your lawyer can do in your franchise agreement that can protect you from fraudulent misrepresentation claims. What do I mean by fraudulent misrepresentation? So if you know what you're saying is untrue, or you don't actually believe what you're saying is true, or you just don't care whether it's true or untrue, that is a fraudulent misrepresentation. And the courts in a franchising context are really quite quick at finding fraudulent misrepresentation, because they say to themselves, the franchisors know about their franchise network, franchisees or prospective franchisees don't, and so franchisees must be able to rely on the franchisor telling the truth. Now, the real problem with misrepresentation usually relates to figures. Most franchisors provide their prospective franchisees with profit forecasts about the franchise, because inevitably a prospective franchisee is going to want to know, how much am I going to make? You have to be very careful with those. Of course you put disclaimers on those, but they have to be based on usually the average performance of your franchisees, not just the performance of your top performing franchisees, but all of your franchisees. Right at the beginning, you can say, well, actually, we have no franchisees who've been operating for the first 2 years or whatever it is, and so I'm basing these figures on what I, the franchisor, have done. And that's okay, but once you have franchisees, you must base those figures on actual performance and not what you would like your franchisees to be doing. So, disclosure, I mean, is it sensible to say nothing to prospective franchisees? Well, even if it was, that's just not commercially possible. So you are going to have to give franchisees information. And indeed, the BFA requires franchisors to comply with the Code of Ethics, which requires disclosure about certain facts. And I'm a big fan of disclosure, telling franchisees stuff about your franchise and doing it in a truthful and honest way seems to me to be a good start to that franchise relationship. The operations manual. You will have a franchise agreement and you will have an operations manual. The operations manual deals with the day-to-day operational issues of a franchise. And it needs to be constantly updated. The franchise agreement will allow you to do that. You don't need a franchisee's consent to do that, so you have a free hand to update it. And in too many franchises, I see the operations manual not being updated for 2 or 3 years. And what happens then is that lawyers use that to demonstrate to a court that you really haven't developed your franchise, and there's often a clause in your franchise agreement that requires you to do that. So there's some real downsides in not constantly looking at your manual, updating it, introducing changes. And in terms of the relationship with the franchise agreement, there is almost always a clause in your franchise agreement that makes a failure to comply with the operations manual a breach of the franchise agreement. So the operations manual is important. The stuff it contains is not optional for your franchisees, and you need to make sure that they comply with it. Next, let's look at dealing with non-performance. Very important that your franchisees are aware of what you consider to be important, and that you apply the provisions of the franchise agreement in a consistent way. Technically, from a legal perspective, there may be good reasons why you don't have to do that. But in terms of the relationship with your franchisees, it's really important that they know what it is they're supposed to do and what it is that you're going to get excited about and what you might not get excited about. So there's a saying in franchising that after you've entered into the franchise agreement, you put it in the desk and forget about it. And that's in a sense very good advice, because it means you don't constantly quote clauses in your franchise agreements to your franchisees. That would destroy the relationship. But in a sense it's bad advice, because it's really important that you and your team know what's in the agreement and use those provisions in the agreement to make sure that your position is protected. Let me just give you one example. Very often franchisors will say to me, we think this franchisee isn't declaring everything. We think he's diddling us. Let's terminate. And I say, well, have you looked at the franchisee's VAT returns? And the franchisor says, oh, I didn't realise we could get VAT returns and we haven't bothered getting them. Almost certainly your franchise agreement will require franchisees to provide you with VAT returns. So make sure that that happens. Make sure your staff knows the powers that the franchise agreement gives you, and its constant updating is required. Now, you've got a franchisee that's not doing what the franchise agreement says the franchisee should do. What do you do? Franchisor once said to me, it's all very well, this franchise agreement, but really, I'm only left with a nuclear option of terminating if a franchisee is in breach and doesn't do what the agreement says. Now, there's a way around that. You provide in the franchise agreement for the ability to serve a breach notice on franchisees. So you notify your franchisees they are in breach. And in addition, I recommend that you impose a requirement that for every breach notice you serve, that there is a payment, because clearly you're going to be incurring administrative costs in serving a breach notice. So make sure that the agreement specifies that there is a payment. And ultimately, if there is no correction of the breach, you're in a termination situation. And we'll talk in a few moments' time about termination. How to deal with disputes? Well, my guiding principle is avoid litigation. Personally, it is the last thing I would ever do. It is unbelievably expensive, unbelievably stressful, and the outcome is never certain. So avoid litigation like the plague. Now, a very good way of resolving issues with franchisees is through mediation. The mediator doesn't decide who's right or wrong, but the mediator encourages a commercial solution. It's much cheaper than litigation. If you get a good mediator, there's a very high prospect of success in resolving it. It avoids a disastrous relationship following a litigation. There is also arbitration, and again, The BFA have a mediation process and an arbitration process. So my advice is avoid litigation. Right, termination. Now bear in mind that when you terminate a franchise agreement, your franchisee loses everything. And that's important because the courts are hesitant, let's put it that way, to allow franchisors to terminate franchise agreements too easily, because a franchisee loses everything. And so there needs to be a paper trail. You need to start off when a franchisee is not performing, not doing what the franchise agreement says, or doing other bad things, to offer help, offer assistance, offer more training, send somebody from your staff around to assist on a day-to-day basis. You need to do all of those things before you start going, look, unless you put things right, we will have no option but to terminate. But eventually you will come to that, and there needs to be a couple of letters indicating that unless this is serious, and the last letter is, look, unless you put things right, we will terminate. So make sure there's a paper trail. Try to resist the temptation of not doing that and then phoning your lawyer up at the last moment and saying, right, this bloke, we've got to get out. How do we terminate? Because that's not a clever way of doing it. I mean, obviously, if your franchisee is doing something really bad, like setting up a rival network, yes, of course, in those scenarios, you can terminate straight away. But that's quite rare. So, make sure you've given yourself the best chance of success by laying a paper trail. Now, if you terminate and if you bring a claim against your franchisee because, for instance, the franchisee hasn't been paying you, you can guarantee or almost guarantee that the franchisee will bring a counterclaim because you'll go and see a solicitor, and it's a knee-jerk reaction that the solicitor says, well, have you got a claim against the franchisor? And the two red-hot favourites are breach of contract. They'll look at the franchise agreement and see if you haven't done the things that the agreement says you should do. And the real favourite is misrepresentation. They'll look at what you provided, and if there's anything in there that may not be truthful, they have a misrepresentation claim. So back to my point about avoiding litigation, always look for commercial solutions. So maybe you've got a franchisee you want out of the system, rather than terminating, say, look, this is not working for us or for you, so we're going to give you a period to sell your franchise. We'll help you sell it. And then at least the franchisee, if it's a profitable business and can be sold, will get something for the franchise. And that tends to avoid litigation. So I told you it was going to be boring. It's really important. So in conclusion, take the legal aspects of franchising seriously. It's one of the very few things that can destroy your network. And I've seen that in quite a few franchise networks, getting it wrong. I'm a lawyer, so you'll say I'm bound to say this, wouldn't I? But it may involve you spending money up front to give yourself the best franchise agreement you possibly can, and having a close relationship with your franchise lawyer, and making sure that that lawyer really knows about franchising. And remember, really work hard to avoid litigation.